Good morning. This is Political Science 201. I'm Laura Fleming. Welcome. This is Lecture 2. Here's a little something to think about. Which government do you trust more? Your national government in Washington, D.C., or your state government in Baton Rouge? Usually when I ask this question, it's about half and half. Half the people trust the national government more, half the people trust their state government more. Those who trust the national government might say things like, maybe they're big Trump supporters. Maybe they feel that Louisiana doesn't have a great track record when it comes to corruption, things like that, or maybe they feel the national government has a better track record. Those who support the state governments sometimes feel that what's best for the country as a whole might not be best for the people of Louisiana, and that the state government is in the best position to take care of and assess the needs of the people in our state. So it's kind of an interesting question, especially when we're dealing with the coronavirus crisis and different government responses to that. In the time of the founders, this was a very easy question. The founders assumed that people would trust their state governments more. I'm reading from Federalist Essay number 46. This is Madison here. He says, it is beyond doubt the first and most natural attachment of the people will be to the governments of their states. Into the administration of these, a greater number of individuals will expect to rise, so it's easier to find a position in state government versus national government. That's still true today. By the superintending care of state governments, all the more domestic and personal interests of the people will be regulated and provided for. So we'll see that at the time of the founders, the national government was supposed to focus on national government things, and the state governments really were responsible for the day-to-day lives of the people. That's not exactly the same as it is today. So today, the national government is much more heavily involved in our everyday lives, but that's not how the founders originally set things up. Madison goes on, with the affairs of the state governments, the people will be more familiarly and minutely conversant. Again, not exactly the case today. If you watch the news, most of the news is going to be on a national level. We have very well-developed national media outlets, and it's sometimes kind of difficult to get news about what our state government is doing in Baton Rouge. Madison continues, with the members of the state governments will a greater proportion of the people have the ties of personal acquaintance and friendship and family and party attachments. Again, even when I ask my students this question, how many of you know someone in government personally? Usually a few people raise their hands. Most of the time it's going to be someone in state or local government. And Madison says on the side of state government, therefore, the popular bias may well be expected most strongly to incline. So the founders expected that people would be very attached to their state governments. Continuing in Essay 46, Madison goes on, and he's talking about his experience in Congress. Remember, under the Articles of Confederation, we had a Congress. Madison participated, and he says, what is the spirit that has in general characterized the proceedings of Congress? A perusal of their journals, as well as the candid acknowledgments of such as have had a seat in that assembly, will inform us the members have but too frequently displayed the character rather of partisans of their respective states than of impartial guardians of a common interest. So Madison is basically saying in a nutshell here that if you look at the notes of Congress, if you talk to people who are being honest about Congress, they'll tell you that the members of Congress really are partisans. They really are biased on behalf of their respective states because, of course, that's where the voters are. Madison says, where on one occasion improper sacrifices have been made of local considerations to the aggrandizement of the federal government. So perhaps every once in a while, some local interest will be sacrificed to the national government. But Madison says the great interest of the nation have suffered on 100 occasions from an undue attention to local prejudices, interests, and views of the particular states. So at that time, what they were dealing with was not local and state interests being ignored on behalf of the national government. It was the opposite. Madison felt, if we're going to be honest, the great interests of our nation were sacrificed on many occasions on behalf of the interest of the states. So again, a little different from what we have today, and we will talk about that. So today we're going to talk about the unique structure of the United States Constitution. Last time we talked about the Enlightenment, the philosophical underpinnings of the Constitution, some of the debates between the Federalists and the Anti-Federalists. So today we're going to talk about what's actually inside this document. There are three unique features we're going to focus on. The first one is the Republican form. Okay, we have a Republican form of government. This means that our government is representative and that people have the opportunity to participate in choosing our leaders. So we'll talk about that. We'll also talk about separation of powers. The founders were all about the separation of powers. Hopefully in high school, when you took American government or civics, you learned about the three branches of government: legislative, executive, and judicial. So we'll talk more about that and where that system came from. Finally, we're going to talk about federalism. Federalism is the relationship between the national government and the state governments. And you'll notice I'm going to use the terms federal government and national government interchangeably. But not all nations have a federal government system. All nations have a national government, but in order to have a federal system, you have to have states. Okay, so we're a nation of states. We're the United States. These states have a certain level of independence and sovereignty. That's not the case with other governments that do not have states, that only have provinces or regions or things like that. So we're going to talk about the relationship between national and state governments. All right, last time we talked about this delicate balance, this trade-off between freedom and security. The idea that if you need security from the government, you're going to have to trade some of the freedom that you had in the state of nature. But that this freedom hopefully will be a worthwhile trade because you'll obtain the security that you need to enjoy your remaining freedoms. Okay, so how do you get the balance right? The founders actually talked about this. I'm reading from Federalist Essay 37. This is on your Accessible Federalist. That's the small book by Professor Adam Seagrave you need to have for this class. Hopefully you have it already. So here is Federalist 37. One of the most important difficulties encountered by the convention, meaning the Constitutional Convention, must have consisted in the question how to combine the necessary stability and efficiency in government with the necessary attention due to liberty and to the Republican form. So here's Madison. He says, efficiency in government is essential to securing citizens against external and internal dangers. So you have to have a certain amount of government power, a certain amount of government energy. Nonetheless, on comparing these valuable ingredients of stability and efficiency, a strong government, with the vital principles of liberty, we see at once the difficulty involved in mixing them together in their due proportions. Okay, so the founders were smart guys, and they realized we want a stronger national government. We need a stronger national government. The Articles of Confederation just weren't cutting it. Nonetheless, they realized the more power you give the government, the more freedom you give up, and they did not want to give up any more freedom than they had to. So this is the solution that the founders came up with. These three unique features we're going to talk about: Republican form, separation of powers, and federalism. Okay, first unique feature, our government is representative. Okay, what does this mean? The Constitution establishes a republic or indirect democracy. We see this in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands. Sometimes people will ask the question, is the United States a republic or a democracy? Well, we have democratic elements in our government, but we are not a direct democracy. In a direct democracy, everyone would meet together and vote on everything. Okay, that's not how it works. Instead, we choose our leaders. We choose those who will make decisions. We don't make decisions for our government directly. And there's very practical reasons for this, as you can imagine. So here is Federalist Essay 14. This is Madison talking about direct democracies. And he says, in a democracy, the people meet and exercise the government in person. In a republic, they assemble and administer it by their representatives and agents. A democracy, consequently, must be confined to a small spot, but a republic may be extended over a large region. He goes on and he talks about the natural limit of a democracy is the distance from the central point which will permit the most remote citizens to assemble. And he says the natural limit of a republic is much greater, the distance from the center, which will barely allow the representatives of the people to meet as often as may be necessary. So we have a great big country. It's just not practical for everyone to meet and make decisions together, but it is practical to choose representatives and to send our representatives to the Capitol to exercise the government on our behalf. I was talking about this to one of my sons, and he said, but Mom, he said, things are different now. You actually could have a direct democracy. He said, you know, you could do it through social media. He said you could have a platform where everybody could go on, anybody could participate, everybody could suggest different laws, people could vote them up and down, and whichever law got the most votes, basically whichever law went viral, then those would be the law of the land. And he said, you know, that'd be great. We could finally have a pure democracy. So let's think about this. What challenges might you face in a pure democracy by social media? So my students will often raise objections like, well, first of all, there would be security challenges. You definitely don't want a system like that to get hacked for sure. And there's access challenges. You want to make sure everybody has access to the technology. That's also true. So let's take a hypothetical world in which all the technology and access problems have been solved. So you have this crackerjack IT team, and they're preventing the system from being hacked. It's very secure, and they have stations at libraries and public places, so anybody who wants to participate can. Would there still be a problem? And at this point, the students start laughing because when you think about it, you know, what kinds of things go viral? You know, sometimes ridiculous things go viral, right? Cat videos, pimple popping videos, and worse, things that are not safe to talk about in class go viral. And the question is, do you really want your government to be run that way? Not only that, there will be a lot of chaos, a lot of uncertainty. And if you think about it, most people don't really have the bandwidth to be on the computer all day dreaming up new laws, right? Most people have to go to school and work and take care of their families. So this means that we would be leaving the government of our country in the hands of a bunch of internet trolls that live in their parents' basement, right? So that would not be good. So you can see, even if a direct democracy was possible, the form that we have, this Republican form, is superior. It's superior to elect leaders, hopefully leaders that we all trust will make good and wise decisions on behalf of the people. If not, we can always vote them out, right? And then we give them the time and the space and the place to work on governing the country. So this Republican form, even if you overcame the technical difficulties, would still be superior to a direct democracy. Okay, so now that we know we have a representative government, the question is, what's the formula going to look like? Okay, so how do you count for purposes of representation? At the Constitutional Convention, the states did not agree on how representation should work. There were different ideas about what the formula should be. And this led to the Great Compromise. Okay, this is one of the reasons why the founders sat in that very hot conference room in Philadelphia for 4 months discussing and debating until they finally came up with a compromise. And here we are. The Great Compromise ended with 2 chambers in Congress. Okay, so Congress, we have 2 units in Congress, and they each have a different formula. Hopefully you guys are familiar with this. In the Senate, the states are represented equally. Okay, so each state gets 2 senators. In the House of Representatives, states are represented by population. So the larger states will have more members in the House than the smaller states. Why was this compromise necessary? Well, you had to get all of the states on board to this new Constitution. And the smaller states were reluctant, and they said, why should we participate in a national government if our interests are just going to get run over by the more populous states? So that's why we have the Senate. And the larger states said, hey, wait a minute, shouldn't we have more weight because we're going to be contributing more? We have more people, more land, more resources, our economies make a bigger impact on the nation, so we should have more of a say, and that's why we have the House of Representatives. So every law, and we'll talk more about this in later lectures, every law has to be approved by both the states as states, that would be the Senate, and the states by population, that would be the House of Representatives. So there was another compromise in the Constitution that we're going to talk about. So the Constitution contains a compromise on the issue of representation and slavery. When we hear this today, we think, oh my goodness, a compromise on slavery, that's terrible. How could you compromise on something like that? And this is where I want to encourage us to step back and not be guilty of presentism. Remember, presentism is a bias against the people of the past in using our current standards to judge them. Okay, so we need to be careful about that. We need to judge historical figures in the historical context in which they lived. So we're going to do our best to do that. The first thing that you should know is that slavery was not uniquely American at all. Many people groups throughout history have practiced slavery. It goes back to the earliest times for thousands of years. every continent across the globe, slavery has been practiced. Now, in the United States, we had kind of a unique form of slavery. So what you had is during the 1600s, when the New World was being colonized, many of the colonists brought slaves from Africa to work in the plantations. And this was true in the southern states, also in the Caribbean and in South America, where you have good growing climates. The original colonists brought over African slaves and continued to use and become dependent on slaves from Africa. Okay, and this is not to excuse this system of slavery at all. It was horrible. It was horrible, especially because you had people primarily of one race, Africans from Africa, being taken across the Atlantic under very difficult and dangerous conditions to work in the New World. It was not a good system. And many of the founders actually recognized this. Okay, so there were some founders who were abolitionists, some founders like Thomas Jefferson and George Washington who owned slaves, but they felt very ambivalent about it, and they felt like the institution of slavery should go ahead and just die out. They were looking forward to a time when there would be no more slavery. And this was based on their political and religious beliefs. So we know that many of the founders were Christian, or at least had a respect for the Bible, and we had the New Testament teachings about freedom in Christ, and the fact that in Christ there is no slave or free. So people were thinking about those things. People were also thinking about Enlightenment philosophers like Locke that we talked about last time. And in the Declaration of Independence, we say that all people are created equal and that freedom is one of our core values. So here are the founders, and they're thinking, you know, if freedom and equality are core values, how do we reconcile that with slavery? And they were struggling with those ideas. So the Constitution happened at a very weird snapshot in time. The times were changing, but they had not changed yet. I want to emphasize that even though there's this compromise on the issue of representation and slavery, a very narrow compromise, the Constitution is not a pro-slavery document. Okay, so the Constitution was not pro-slavery. You had founders on different sides of this argument, and they were very careful to thread this needle and leave the question of the abolition of slavery to their descendants under the constitutional system. So the continuation of slavery was potentially possible under the Constitution, and the abolition of slavery was also possible under the Constitution. So let's take a look at the exact compromise that the founders came up with. It's called the 3/5 compromise, very misunderstood. Under the 3/5 compromise, slaves were counted as 3/5 of free persons. So here is the very narrow question the founders were trying to answer. We know in the House of Representatives that states are counted by population for purposes of representation. So the greater your population, the more power, the more representation you have in Congress. So the question was, should slaves be counted? If slaves are counted, then the southern states that have slaves would have more power in the House of Representatives. Remember, this is irrelevant to the Senate because in the Senate, states are represented equally. So it doesn't matter whether a state does or does not have slaves. But in the House of Representatives, you had to decide, do slaves count for purposes of representation? So this is how it went down. The South wanted to count slaves 100% for representation and 0% for taxation. So back then, there was the potential for the national government to raise taxes by population. And so the South said, hey, I know what, let's have slaves count 100% for representation so we have more power in Congress. And how about 0% for taxation so we don't have to pay as much taxes? And the North, of course, was the opposite. The North wanted to count slaves 100% for taxation, make the South pay more, and 0% for representation. So South gets less representation in Congress. Under the 3/5 compromise, slaves were counted as 3/5 of free persons for both. So you can see this kind of trading going on, trying to decide what the number should be. We want 1/2. No, we'll give you, 3/4. And finally, they come up with 3/5. This is not some kind of declaration that a slave was only morally the equivalent of a free person. Okay, it doesn't have anything to do with the dignity accorded to a slave morally. It just has to do with the formula for purposes of representation. So I'm going to give us an example so that perhaps we can understand the predicament of the founders a little better. Today we do have a group in the United States, a group that is marginalized, a group that performs a lot of the manual labor and service jobs in our economy. And I'm talking, of course, about undocumented immigrants. The story of undocumented immigrants is different from the slaves, of course, in the fact that the immigrants came here voluntarily. So nobody forced them to come here. They're not slaves, but they are a controversial people group in the United States. So let's say that you're in a conference room. You're trying to establish a new form of government. You know that you want a Republican form. You want representation. And let's say someone raises the question, should undocumented immigrants count for purposes of representation? And let's say in this conference room, you have two groups that let's say it's very polarized, all right? So you have one group wearing the red hats and saying, build the wall, build the wall. And then you have the other group saying, that's not who we are, open the borders and give free health care to all the immigrants. And you know that you're not going to be able to solve this question in this conference room. Okay, you're not going to be able to solve the debate about immigration in this conference room. You're actually trying to do something more important. You're trying to establish a form of government because if you don't have a government, then you're just going to have anarchy and chaos, and you won't be able to resolve the immigration debate ever. Okay, so you're down to first principles. You just want to establish a government. The only question you want to talk about is, what is the formula? How should we count undocumented immigrants for purposes of representation? And you can imagine the two groups going back and forth about how they should count, and then perhaps coming up with some very bizarre number like 3/5. Now, people have asked, what do undocumented immigrants count for purposes of representation? Like, what is the current status on that? We have the census coming up this year, 2020. Are undocumented immigrants counted? And the answer is yes. So the census takers go from house to house, and they don't leave out people who are undocumented. They count everybody who's there. Okay, so the census takers don't check papers. They don't make decisions as to who's documented, who's not documented. Undocumented immigrants are present, and for purposes of representation in the House, undocumented immigrants are counted. So what this means is that states like California and Florida, Arizona and Texas, these states actually do have more representation. They have more power in the House than they otherwise would if undocumented immigrants were not counted. Okay, so this is just a little exercise to see if we would be able to solve a very narrow question: what should the formula for representation be? And put aside the larger moral question about how the country should handle immigration. The hope is that if you get a government in place, that maybe people can work that through in a democratic manner. All right, let's talk about the second unique feature of our Constitution. Our Constitution separates government power into three branches. Article 1, or Chapter 1 of the Constitution, is all about Congress, the legislative branch. This is the first article in the Constitution. It's also the longest, and it represents the importance that the founders placed on Congress. Congress is responsible for making the laws, and as we just discussed, Congress is made up of those two chambers itself, the Senate and the House of Representatives. Then we have the executive branch. The executive branch includes the president, and we'll also talk about the fact that the president is not the only member of the executive branch. There are actually many independent government agencies that constitute the executive branch as well. And the executive branch is responsible for carrying out the will of Congress, for enforcing the laws. And the powers of the president are discussed under Article 2. Then we have the judicial branch, the Supreme Court, responsible for interpreting the laws. Not just the Supreme Court, but the entire federal court system. This is discussed in Article 3 of the Constitution. So the first three articles of the Constitution have to do with the separation of powers. This is really the meat and the potatoes, the structure of the government that the founders were so concerned about. If you click on the link in the header, our Constitution separates government power into three branches. If you click on that link, it's a little clip. This is former Senator Claire McCaskill. She got herself into a little trouble talking about how our founders were maniacal about separation of powers, basically calling our founders maniacs. But it's true, our founders were maniacal. They were maniacs about separation of powers. It was very important to them, and we're going to talk about why. Okay, last time I had asked you to read Federalist Essay 47. This is one of the Federalist essays that was helpfully translated into modern English by Professor Seagrave. So we're going to take a look at that starting on page 29. All about separation of power. This is Madison, and he says at the bottom of page 29, the accumulation of all powers, legislative, executive, and judiciary in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elected, may fairly be called the very definition of tyranny. So Madison is saying if you have all the power in one set of hands, and it really doesn't matter if it's just one person, a dictator, or whether it's some kind of group or Congress, regardless, if all the powers are in the same hands, then you're going to get tyranny. Now, Madison didn't come up with this idea. He gives his citations. He attributes this concept to the Enlightenment philosopher Montesquieu. So this is on page 30 of the Accessible Federalist. Madison says, "The authority who is always cited on this subject is the celebrated Montesquieu. If he is not the author of this invaluable political principle, he has at least presented and recommended it in most effectively to the attention of mankind." All right, so the Enlightenment philosopher Montesquieu, and we'll talk about him in a minute, was the person who kind of popularized the idea of separation of powers. He says, this is on page 31, "When the legislative and executive powers are united in the same person or body, there can be no liberty, because apprehensions may arise lest the same monarch or senate should enact tyrannical laws to execute them in a tyrannical manner." For example, if you have a dictator is basically the same person making the laws, executing the laws, and also deciding individual cases. That's a problem. Okay, so when you have separation of powers, the branches can check each other. So if Congress comes up with a law and the president is not sure about the wisdom of that law, the president can mitigate some of the effects in terms of how strongly and rigidly the president enforces that law. And again, when judges are applying the law, they can also mitigate some of the effects in terms of how they interpret and apply it. Here's another reason for separation of powers. Okay, when I was young, I had 3 brothers. And let's say that me and my oldest brother were in the kitchen and there's only one cookie left. Okay, so this could be a crisis here. 1 cookie, 2 kids. And so we go and ask our mom about this situation, and this is what my mom would say. She would say, "Okay, Laura, you cut the cookie, and then my brother could pick which piece of the cookie he wanted." Okay, this is a mini separation of powers. You're separating the power to cut the cookie from the power of choosing or distributing the 2 halves of the cookie. So you better be sure that I'm going to cut the cookie very carefully so that my brother can't get an advantage by taking a larger piece. If you have consolidation of power, for example, if my brother had the power both to cut the cookie and to distribute the cookie, there's a very good chance that he would act in a tyrannical manner, that he would cut the cookie so that there was a large piece and a small piece, and that he would give the small piece to me. Okay, so that's an example of the checks and balances involved with distributing power. One other thing I'd like you to notice about Federalist 47, and this has to do with how maniacal James Madison was. Remember, he came to that Constitutional Convention highly prepared. He had studied constitutional documents in Europe, and he'd also studied separation of powers in each of the 13 state constitutions. And you can see, starting on page 31, he goes through them one by one. New Hampshire, Massachusetts, Rhode Island, Connecticut, New York, New Jersey, page 33, 34, South Carolina, Georgia, on. And he looks at how separation of powers works in each of those state constitutions. And his goal was to come up with the best mechanics for our national constitution. So that just goes to show James Madison, smart guy, really did his homework, and that's an example of just how maniacal he was. All right, so the basic idea is that separation of powers prevents abuse of power. Again, this is attributed to the Enlightenment philosopher Montesquieu, who was a French attorney. We don't want you to forget about our other Enlightenment philosopher here. So I have a little photobomb from John Locke. So we have John Locke, the English doctor, and Montesquieu, the French lawyer. Here's a quote from one of Montesquieu's books. Okay, so we read you a little bit of John Locke last time. We're going to read you a little bit of Montesquieu this time. Obviously, Montesquieu wrote in French, but we do have translations available. And Montesquieu says, constant experience shows us that every man invested with power is apt to abuse it. To prevent this abuse, it is necessary that power should be a check to power. So Montesquieu said, look, we know this from experience. Anybody with power has the very real temptation to abuse it. One way you can prevent this abuse is that you can have power checking power. You can divide the powers across the government so that no one person has ultimate power. That's from Montesquieu's book, The Spirit of the Laws, written in 1748. So, separation of powers basically helps the government control itself. Now we get to Federalist Essay 51. This is probably the most famous of the Federalist essays. Federalist 51, probably one of the top two. And here is Madison. He says, it may be a reflection on human nature that such a method, this idea of power being a check to power, separation of powers, such a method is necessary to control the abuses of government. He says, you may accuse me of being a cynic about human nature. And what does Madison say? He says, guilty as charged. I am a cynic about human nature because what is government itself but the greatest of all reflections on human nature? He says, if humans were perfect, if they did not have selfish, inherently destructive tendencies in their nature, if we didn't have that, guess what? We could live in the state of nature. Everybody could be sweet and kind to each other and thoughtful. There would not be any problems. The only reason we need government in the first place is because human beings are corrupted. Okay? So if men were angels, this is Madison again, if men were angels, no government would be necessary. If angels governed men, neither external nor internal controls on government would be necessary. So he says, guess what? If people were angels, you would not need government in the first place. Here's the problem. Our leaders, our government is also made up of only people. Okay, so if we had angels in charge, then we wouldn't need separation of powers, right? If you had a dictator, but this dictator was wise and benevolent and good, that'd be fine. Okay, so a wise, benevolent, and good dictator would give the people freedom and would govern justly, and you wouldn't need to bother about separation of power. So the problem is not only are people corrupted, but our leaders are just people. They're not angels. They're corrupted too. So here's the famous quote. In framing a government which is to be administered by men, not angels, over men, not angels, the great difficulty lies in this. You must first enable the government to control the governed. You have to give the government sufficient power to make sure that we have law and order and to control the people. But you also somehow have to obligate it, have to oblige it to control itself. So the government has two jobs, not just controlling the people, but also controlling itself. And that's why we have separation of powers. Question is, how do you keep the powers separate? So again, Madison and the other founders thought a lot about this. They didn't want the powers only to be separate on paper. They wanted the powers to actually interfere with each other and keep each other checked. So separation of powers does not make the powers independent. They are not independent of each other. In fact, the founders purposely made it so that the powers would get all up in each other's business. They're separate, but they have constitutional control over each other. This is from Federalist 48. Madison says, unless these departments be so far connected and blended as to give each a constitutional control over the others, the degree of separation essential to a free government can never in practice be duly maintained. So the departments have to have the ability to poke each other and tweak each other and give each other a hard time and get all up in each other's business, or else they won't truly be separate. A mere demarcation on parchment, a mere paper separation is not a sufficient guard. This is where we get to checks and balances. Each branch of government has some power over the others. This is called checks and balances or veto points. So, for example, the president can veto a law passed by Congress. We're going to see that it's actually quite difficult to get a law passed. You have to get a majority of the House and the Senate on board. Not an easy thing. A law can go all the way through that process, and then the president can veto it. The president can either sign it or say, I'm not interested in this law. Thumbs down, even if Congress has worked really, really hard on that law. Another example, the president appoints judges. So it's the president's responsibility to appoint judges to the federal court system with Senate approval. Okay, so the Senate actually has to approve the judges that the president appoints. And we've seen that can get controversial at times. Judges have power. They can declare the actions of the president or Congress unconstitutional. We'll see that's a very strong power that a law can be passed. The president can sign it. But if the judge does not believe the law to be constitutional, if the judge feels that the law is not in line with what the Constitution says, that judge can actually refuse to apply it. Congress can override the president's veto. So if Congress really wants to pass a law to the point that they have a supermajority, a 2/3 majority, they can override the veto and pass the law anyway. Congress can also block or impeach presidential appointments, specifically the Senate. The Senate can block or impeach presidential appointments. Now, many people today complain about all these checks and balances. So this is from the textbook, page 45. It says, fragmentation of power has prevented many abuses of power, but the system's very advantage has become its primary disadvantage. In their efforts to fragment power so that no branch could accumulate too much, the founders divided power to the point where the government sometimes cannot marshal enough. At best, the system moves inefficiently and incrementally. At worst, it moves hardly at all. The Constitution has established a government that is slow to respond to change. The U.S. government works within a set of limits designed to prevent it from working too well. And this is frustrating for many contemporary Americans who want the government to tackle the problems we face. We'll talk more about this, but it is true that modern Americans expect the government to operate smoothly and efficiently, And when we look at this system, we see it was actually designed not to work smoothly and efficiently. So that is a tension inherent in our national government that we're going to explore more over this course. Okay, so now we're going to talk about the third unique feature of our government. We have both national and state governments. This is called federalism. So we live under the government of each of our states. So in my case, it's state of Louisiana. And we also live under our national government. So how does that work? So the states originally were sovereign and independent. Okay, so the states had a great deal of sovereignty. They saw themselves as the primary government unit for their people. When we talked about the United States, it was the United States plural. The United States are a great place to visit. For example, today we talk about the United States singular, one nation, and we'll get into how that change came about. But originally the states were sovereign and independent. So the question was, if there's a conflict, what happens if there's a conflict between the laws of a particular state and the laws of Congress? Which law should the people follow? What should you do if there's a conflict between national law and state law? That is addressed in Article 6 of the Constitution. This is called the Supremacy Clause. So if you open your accessible Federalist, the Constitution is included in the back. I'm looking at page 108, Article 6, Article VI, for those of you who may not have had Roman numerals in school, and you can write next to that supremacy. This is the Supremacy Clause. I'm going to read it to you. This is paragraph 2. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. So this United States Constitution and these laws passed by Congress pursuant to the Constitution shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. So the idea is that we don't care. We don't care what your state law says. We don't care what your state constitution says. If it conflicts with national law, national constitution, then national law is supreme. Okay, that is the Supremacy Clause. That's a little scary, right? So why would the states agree to that? Why would they agree to give up their power in that way? Here's Madison in Federalist Essay 44. He says, basically, it has to be that way. The national government has to be sovereign. In conclusion, if the states were sovereign, the world would have seen for the first time a system of government founded on an inversion of the fundamental principles of all government. So Madison says if the states are sovereign, that turns the world upside down. That turns political science upside down. States cannot be sovereign. The world would have seen the authority of the whole society everywhere subordinate to the authority of the parts. It would have seen a monster in which the head was under the direction of the members. Okay, so if the states were sovereign, according to Madison, it would be a monster. And I was trying to think, what kind of monster might Madison have been thinking of? And I looked on the internet, and there it is. Okay, so this is the monster Incredipede. Okay, so I found him on Steam. You can take a look. He has a lot of arms and legs sticking out all over the place, and you can see it'd be kind of difficult to navigate if you were an incredipede, because your arms and legs are sticking out and competing with each other and pulling you in different directions. And Madison says incredipede is what we don't want for the United States. Okay, we want a nice orderly system where all of the body parts obey the instructions from the head, which would be the national government. However, Madison says, don't worry, states. I'm going to tell you why you don't need to worry. This is also from Federalist 45. He says, even though the laws passed by Congress are supreme, even though national laws are supreme, national power is limited. This is from Federalist 45. The powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in the state governments are numerous and indefinite. The national government will be exercised principally on external objects like war, peace, negotiation, and foreign commerce. So basically, national government is going to do national government things: war, peace, negotiations with other countries, trade with other countries, etc. And he says, don't worry, the powers reserved to the several states will extend to all the objects in the ordinary course of affairs that concern the lives, liberties, and properties of the people and the internal order, improvement, and prosperity of the state. So state governments, don't worry, even though national power is supreme, you're going to be in charge of all the day-to-day things that you and your people are worried about. The national government is only going to worry about national government stuff like war and negotiation and trade. All the other stuff, the state governments will remain sovereign because the national governments aren't going to bother with it. Okay, this was the compromise reached between the national government and the states. The national government has enumerated and limited powers under the Constitution. That word enumerated just means there's a list. There is a list of powers of the national government. That list is contained in Article 1, Section 8. Remember that Article 1 is all about Congress. So in Article 1, Section 8, we find the list of the things that Congress can do. The idea is that if it's on the list, Congress can do it. If it's not on the list, then Congress cannot do it. So if you look at the list, that's on page 100 of your Accessible Federalist. Okay, remember, a copy of the Constitution is in the back of the Accessible Federalist. Turn to page 100, you'll see Section 8, all the powers of Congress. And just because there's a list does not mean it's a short list. Okay, this is a very powerful national government, more powerful than the Articles of Confederation. So the powers are significant, but they're still limited. So for example, Congress can tax. The national government can tax. At the time, taxes were not as expansive as they are today. The government could not impose an income tax, for example. That came later, but they could impose taxes by population, theoretically, and also impose taxes on imports and exports. Under Article 1, Section 8, Congress could also regulate interstate commerce. This is called the Commerce Clause, and it basically means that Congress can regulate trade between the states and also trade between the United States and other countries. If you look at the list, it says Congress can coin money, it can define citizenship, it can establish post offices, it can declare war, which we'll talk about later, the war powers of Congress, etc. And at the very end, that last paragraph, paragraph 18 on page 101, says Congress shall have power to make all laws necessary and proper for carrying into execution the foregoing power. So Congress has the powers on this list and any associated powers that are necessary and proper for carrying out the list of powers. If you go on in Article 1 to Section 9, there's a little list of things Congress cannot do. For example, Congress cannot spend without an appropriations bill. We'll talk more about that. Basically, it means Congress has to pass a law in order to spend money. Congress cannot grant titles of nobility. We don't have a two-tiered system here in the United States. We don't have earls and lords and ladies and knights and things like that. It's prohibited by the Constitution. Then if you go on, Article 1, Section 10 is addressed to the states. There's certain things states cannot do. For example, states cannot make treaties. Louisiana can't do an end run around President Trump and go sign its own peace treaty with North Korea. Louisiana can't have its own trade agreement with China, etc. We cannot coin money, so there are no Louisiana dollar bills with the face of Huey Long on them, or the face of or a fleur-de-lis or something like that. We can't make our own money. States also cannot grant titles of nobility. So no matter how much my husband might want to be the Duke of Duboc, that is not permitted under the Constitution. So let's take a look at this. We've talked about the things Congress can do. We talked about the things Congress cannot do. Talked about the things that the states cannot do. And now I'm wondering, what about that final list, the list of things that the states can do? Is there an Article 1, Section 11? And you look, and lo and behold, there is not. The Constitution actually does not say what states can do. And the question is, why not? Is it incomplete? What does that mean? What it means is that the states can do anything else, okay? Anything not prohibited to the states, they can do. And the reason we don't have an Article 1, Section 11, we don't have a list for the states of the things that they're permitted to do, is because the list would be too long. The founders anticipated that the states would do all the regular stuff, everything having to do with the daily lives of the people. That was left up to the states. Their powers were not limited like the powers of the federal government. Okay, let's keep going. So national law, although it's supreme, is still subject to the Constitution. What happens when the national government does not act according to the Constitution? Well, we see the answer to this question in Federalist Essay 33. The founders say if the national government does not act according to the Constitution, if they ooze out of the box, they exceed the list in Article 1, Section 8, these will be merely acts of usurpation, unjust power grab, basically, and will deserve to be treated as such. Supremacy is confined to laws made pursuant to the Constitution. So the Constitution says not all laws passed by Congress are supreme. Only the laws made under this Constitution are supreme. Only the laws made under Article 1, Section 8, that list, are supreme. So there are many examples throughout history where state and federal governments have clashed. I'm just going to pick one example. Okay, so this example is marijuana legalization laws. Okay, so states have clashed with federal law over marijuana. This goes back to 1970. President Nixon declared a war on drugs. He convinced Congress to pass the Federal Controlled Substances Act. This law passed by Congress bans marijuana as well as other controlled substances. These are different drugs that Congress deemed dangerous to the American public. And you may ask, okay, how does this fit with the list? You said that Congress has a list of permitted powers under Article 1, Section 8, and if you look very carefully, you don't see any powers relating to banning substances like marijuana. And the answer to that question is that the list of powers, unfortunately, is a little squishy, okay, and subject to interpretation. And in particular, that Commerce Clause has been used by the federal government to gain additional powers that were not originally contemplated by the founders. So if you look at the Commerce Clause, it says that Congress has power to regulate trade between the states, and actually, you know, most things in life will flow in the stream of commerce. Most things have passed over state borders and become part of interstate commerce, interstate trade, and Congress has used the Commerce Clause to regulate many aspects of American life, including but not limited to marijuana. So that's how they got away with it. And they said marijuana is on the list if you consider marijuana part of commerce or trade between the states. Now, since 1970, attitudes of people toward marijuana have changed, have liberalized. More people are accepting marijuana as a substance. And so at this time, approximately 33 states, the majority of states, and Washington, D.C., have legalized marijuana in some form. So if you look at this map, you'll see there are some dark green states like Louisiana. These are states that have legalized medical marijuana, so you have to get a prescription, and there may be other restrictions. Some of these states are neon green, and those states have gone ahead and just legalized recreational use of marijuana as well. So you can see there's a conflict here, a conflict between state law and national law, and which one will triumph. Now we're going to talk about the court system. Okay, so if you're a member of the pro-marijuana lobby, you want to see marijuana legalized, you have a problem with the Controlled Substances Act, one of the things you can do is you can file a lawsuit. Now, when you file a lawsuit seeking to legalize marijuana, seeking to have a law overturned as unconstitutional, first thing you have to do is find a sympathetic plaintiff, a sympathetic person to bring that lawsuit on their behalf. So you don't go out to the street corner and pick up a gangbanger and say, you know, I'm filing a lawsuit, you violated his constitutional rights. No, you have to look for somebody that's going to be sympathetic, that's somebody that the courts will want to help. And so this is the case. Gonzalez versus Reich went up to the U.S. Supreme Court, the case that decided what to do about marijuana. In particular, at this time, this was about 16 years ago, California and only about 9 states had medical marijuana. And so this is the story of 2 ladies, Angel Reich and Diane Monson. I'm reading from the case now. California residents who suffer from a variety of serious medical conditions and have sought to avail themselves of medical marijuana pursuant to the terms of California law. They're being treated by licensed family practitioners, so not just some quack doctors, and these doctors have concluded after prescribing conventional medicines that didn't work, marijuana is the only drug available that provides effective treatment. Both women have been using marijuana for several years pursuant to their doctor's recommendation, and they rely heavily on cannabis to function. Indeed, Ms. Reich's physician believes that foregoing cannabis treatments would certainly cause her excruciating pain and could very well prove fatal. Okay, so here we have it, the two most sympathetic potheads in the world. Okay, Ms. Reich in particular, if you take away her marijuana, she's going to suffer greatly, perhaps even die. Okay, so how did this go down? What happened was, in August 2002, county sheriffs and agents from the Federal Drug Enforcement Administration, the DEA, so you have both state and federal government officials, came to Ms. Monson's home. After thorough investigation, the county officials concluded that the use of marijuana was lawful under California law. So the state guys basically said, nothing to see here. She has a prescription. This is out of our jurisdiction, and she left. But the feds had a 3-hour standoff with this poor sick lady, at which point they seized and destroyed all 6 of her marijuana plants. And at that point, she filed a lawsuit. It went to the Supreme Court. The Supreme Court had to decide, was it constitutional for these federal agents to destroy Ms. Monson's marijuana plants, even though it was legal under California law. And so the Supreme Court thought about it, and they actually came down in favor of the feds. They said, Supremacy Clause, CSA, Controlled Substances Act, is a valid exercise of federal power, even as applied to the troubling facts of this case. So what do? Federal government has exerted its supremacy in this area of legalization of marijuana, and yet more and more states are passing laws that are in conflict. Supreme Court held that federal law on marijuana is supreme, but we still have one branch of government left. We have the executive branch. Okay, so federal agents now have a policy against enforcement in states where marijuana use is legal. So President Obama's administration decided it was not a good use of taxpayer money to send the feds out to harass poor sick ladies in states where use of marijuana is legal. And so here you have the second branch of government, the executive, choosing not to rigorously enforce the Controlled Substances Act where marijuana is legal under state law. All right, this is an academic discussion, okay? I don't want you to go back to your dorm room and say, oh, my political science instructor said I could smoke pot because, look, Louisiana is green. Let me just give you a little life advice here, okay? You'll see that Louisiana is dark green. That means Louisiana only recognizes medical marijuana, and Louisiana has restricted that further to patients suffering from debilitating medical conditions like cancer, glaucoma, HIV, AIDS, cachexia, wasting syndrome, seizure disorders, epilepsy, spasticity, severe muscle spasms, Crohn's disease, muscular dystrophy, or multiple sclerosis. If you have any of these disorders, God bless you, go get a prescription and you can enjoy your pot in peace. But for those of you who do not fall into that category, I have it on good authority that the police at Louisiana Tech do have a policy to enforce the prohibition against marijuana. Okay, so you should understand the law in your particular state. Again, this is an academic exercise talking about federalism. There's another question I can't help but ask, and that is marijuana, legalization of marijuana, is it a negative freedom issue or a positive freedom issue? Think about that. Negative freedom says, government, leave me alone. Positive freedom says, government, help me. If you want to legalize marijuana, what conception of freedom might you have? It's an interesting question. The first reaction is generally why, of course, it's a negative freedom issue. We want the government to leave us alone so we can smoke our pot in peace. Okay, so that's the most obvious answer. But there's also a contingent of the marijuana legalization lobby that's coming at it from a different direction. And they say, actually, what we don't want the government to leave us alone completely. We need the government's help because pot is not regulated right now. Okay, we need the government to help us ensure a safe, legal, healthy supply of pot. You know, how do we know whether the pot is pure, whether it's organic? We don't know the nutritional ingredients on that pot brownie. You know, the pot industry needs more government involvement, more government regulation, more information for consumers. So you can see there's, you know, an interesting marriage of influences here. The people who believe the federal government should leave people alone in their use of substances, and those who believe that the government should go one step further and actually help us regulate and ensure that these substances are safe. All right. Again, we have not just the horizontal separation of power between branches, we have separation of power on this vertical level, separation between national and state governments, and this also helps prevent abuse. In the Federalist Papers, specifically Federalist 46, we read, ambitious encroachments of the federal government on the authority of the state governments would not excite the opposition of a few states only. So in other words, if the feds overstep their bounds, try to ooze into some of the powers reserved to the states, that the states would get excited about that. There would be signals of general alarm. The states would push back against expansive use of national government authority. And then we have this phrase, what degree of madness could ever drive the federal government to such an extremity? The founders, couldn't imagine that the national government would even want to get involved with the lives of the citizens of the states to that degree. So what happened? It has to do with money. I'll tell you what happened. Today, the states are financially dependent on the federal government. This is called fiscal federalism. It has to do with the flow of money. So in the time of the founders, the national government did not have a good way to collect money directly from the American people. So the money either came from import and export taxes, or the national government was going to have to impose taxes on the states by population, and of course that was not very popular. So there wasn't a good way for the national government to get money. That all changed during the progressive era that we'll talk about next time. That changed with the 16th Amendment. The 16th Amendment to the Constitution allowed the national government to impose an income tax. And so now the national government had a source of income directly from the people without having to go through the states. And so what happens is the national government gets money, and then the national government redistributes that money to the states to implement different various federal programs. Okay, so the feds collect taxes, they give the money to the states for federal programs. These programs include grants for welfare, grants for education, grants for health care, subsidies, military efforts, to the point that federal government spending on average represents about a fifth, 20% of the gross domestic product, the economy of many states. If you look at this map here. This is a map of the different states. This is the percent of state revenue from the Fed. So each state government has their own budget and they spend money on programs in their state. But many of these state budgets are heavily dependent upon money from national taxes, especially Louisiana. You can see Louisiana is dark blue. You know, over a third of the Louisiana state government budget comes from the feds. And you have this competition between states for taxpayer money from the national government. They even hire lobbyists, etc. So how do you think this impacts the ability of states to challenge federal power? When you're getting money from the national government, money that you need to operate programs within your states, money that benefits the people in your state and that you don't want to lose, you're going to be more reluctant to make a big challenge to the policy of the national government. For example, Louisiana used to consider that college students should be able to drink wisely. Okay, so Louisiana did not have a drinking age of 21. It used to be 18, so college students could drink legally in Louisiana. What happened was that the national government was giving out money for highways. Louisiana wanted a piece of that money to help improve our highways, and the national government had strings attached. They said, if you want this highway money, then you're going to have to raise your drinking age to 21. Now, Louisiana could have said, you know, we don't want your stinking highway money. We want to let our college students drink legally. But that really would have been unfair to the citizens of Louisiana, because the citizens of Louisiana pay their taxes just like everybody else. Their money goes into the National Highway Improvement Fund just like everybody else. So why shouldn't they get the benefit of that? If you turn it down, that means Louisiana is paying for highways in other states and not getting any benefit for its own highways. And so that's a lot of pressure to change your laws. In the end, Louisiana and other states did cave. They did raise the drinking age to 21, and that things like that happen all the time. This is how the national government has exceeded the powers given to it under the Constitution. The states are not financially able to fight back because they're dependent on federal dollars. So the founders put all kinds of protections into our Constitution. These protections include the Republican form, the ability of voters to participate in who our leaders are, the separation of powers between the three major branches of government, the checks and balances, and finally the limits on national power and the ability of states, at least in theory, to fight back if the national government gets too powerful. But the founders believed that the final protection of our freedom would be you, the American citizen. This is from Essay 29. Federal power can never be formidable to the liberties of the people, while there is a large body of citizens who stand ready to defend their own rights and those of their fellow citizens. So the founders believed Americans loved their freedom, and they stood ready to defend their freedom just as they had done in the Revolutionary War. There's kind of a cautionary word from Federalist 46. We have to be careful of blind submission to the long train of insidious measures that might lead to our freedoms being diminished. Okay, so the way that our freedoms have been diminished did not happen all at once. It happened over a period of time. We'll talk about that when we talk about how the Constitution has changed. So, you know, something to think about. If you feel that a freedom is worth fighting for, then the founders believed that you should go ahead and do that, that you are, the American people, are the final protection for our freedoms. Okay, please prepare for the next lecture. I'd like you to read the amendments to the Constitution. That's in the Accessible Federalist, pages 109 to 118. We're going to talk about how the Constitution has changed over time. Also, please email me with any questions. If the question is of general interest, I can address it during the next lecture, and you can be famous. I will attribute you by your first name if you would like me to do that. Okay, so please prepare for the next lecture. Thank you for listening, and we will talk soon.